Johan van der Walt, the main witness and author of the forensic report in the corruption trial of former President Jacob Zuma and French arms company Thales, has passed away. He died in Johannesburg yesterday. To give us a little bit of insight in terms of exactly what does this mean, I am joined now by Tyrone Maseko for this conversation. Tyrone, thank you so much for your time this evening. Let's talk a little bit about exactly who Johan van der Walt was.
Well, as I understand it, he's the accountant expert, really. You have to understand with cases like this is that there's a lot of following of the money and transactions and things like that. Now, you have to present that evidence in court. It's not good simply making allegations of, this happened on this particular day and so on. You have to be able to explain to the court where the money came from, how it moved, and for what purpose it was moved. I mean, racketeering is a charge in which it's not simply good enough to say, well, I was in possession of X amount of money. You got to show what was the purpose and from whom did it move and for what purpose. And so how then do you present this evidence? It's very difficult to get what you call lay witnesses, as it were, to explain all of this. So typically you get experts, people who come in and do the forensic part, examine these transactions, and typically we'd get external parties, law firms, in this case you'd get audit firms, and they would prepare this report, having done this study. So as I understand it, he would have done all of this and presented a report to court. He still has to give evidence in court and be cross-examined and ask questions on it, and that's where it gets tricky now if you are the author of a report. How do you present? So the report itself does not serve any purpose before court until it is actually presented in court.
Okay, then how significant then has his death now become, as you're saying that the report has to be presented in court, and the best person to present this report would be the author of the report. Now that the author of the report is deceased, what does this mean for the case?
Well, two things. So fortunately, when you're dealing with expert witnesses, typically you're dealing with people who come in after the fact, so after an offense has been committed, meaning that their work is really to analyze what has happened, as opposed to factual witnesses who are eyewitnesses. And you cannot replace an eyewitness. When someone saw an event take place, only they can speak to what they saw. Now, in this case, we're dealing with a party who came after the fact. So they would have prepared the report and they would have worked with the NPA as to how this evidence is going to be presented. So while it is not ideal for the state that now they've got to find a replacement person to present the evidence, however, the evidence does not change. And in this case, I'm not previous to how many people would have worked on this report, but it's not inconceivable that you can have more than one person over a period of time doing all of this work. So to the extent that there are one or more people who actually understand the work that was done, how it was done, and are able to present the evidence to court, then it is not detrimental, or certainly not the end of the matter for the state. It may very well be that they're still in a position in which they can present the evidence, but then they're going to have to go back and start the preparation.
In other words, Tyrone, what you're saying is that the significance here is that we could experience yet another delay.
Well,
as if we have not been delayed already.
Yes, but you got to keep in mind that expert witnesses typically come at the end of the trial. So they don't come. This is a trial in which we've got, I don't know, in excess of 200 odd witnesses, potentially, not that all of them are going to be called. But typically expert witnesses come after your factual witnesses have given evidence. So there is time still to do the preparation. Especially, I mean, they're going to make a call. The NPA would know better. They have to make a call as to whether they can still present the same report. I've not seen this report, so we don't know how extensive it is. It may be necessary to somewhat redo the work, depending on how much work needs to be done. But if the report is intrinsically linked with the person who prepared it, then it becomes difficult for another person to own that report, and then you may have to get them to do their work. But if it is such that you had more than one author working on this thing and their knowledge is very intimate about the contents of the report, then it may be easy to simply replace them, because you're not bound to call any one expert. Accountants, you can have many accounting experts.
Well, then, if his job, Johan van der Walt, was to track the money, follow the money in the money trail, if he is no longer there and he's no longer a witness, and as you're saying, there could be other people that have been involved anyways in compiling the report, so it may not be as detrimental as it may seem. However, when it follows the money, what is the likelihood now of the former head of state's defense team saying, actually, guys, we need to throw out the complete report altogether simply because the person that was key to it, maybe not, you know, one of the key people, but the person that was key to it is no longer there. The credibility of the report will now be in question. We can't be cross-examined, the guy who seemed to be the key person of this report. So let's throw the whole thing out and no longer use it in court. Is there a likelihood of that happening?
They cannot make that argument the way that you present it. So the idea, yes, you could want to tackle in the sense that, well, whoever the prosecution then prefers as a person who's going to present the report in court and speak to it actually does not have intimate knowledge. Because they cannot choose witnesses for the state. The state can present whichever witnesses they want. They can cross-examine that witness. Now, in that cross-examination, they could very well attack the credibility and the understanding of the rules. Simply say, well, you don't know enough of this, and you know, they may make their work easier for them. But you cannot simply say, well, this person does not know anything about the report. You cannot present them as a witness, because then you'd be effectively choosing a witness for the state. The state has got to pick their witness and be satisfied that that person is going to be a good witness, and then subject that person to cross-examination. So, and typically with a report like this, it's unlikely that only one person would have worked on it. You may very well have 2 or 3 or 4 very senior people working together to put together, because there's a lot of work that goes into it over a long period of time. Yeah. So it is conceivable that there may be someone who actually does have a very intimate understanding of the work that's been done. But we don't know. But it is a setback for the state, without a doubt, that's for sure.
Yeah, I mean, speaking about a setback for the state, and this case has been this trial has been about decades coming already. So as we are right now, we're in possibly over 10 years of a delay, so as to say, in actually getting to a point where we hear what exactly happened when it comes to the arms deal. Never mind that, we're still going back and forth around whether or not we should have the lead prosecutor recuse himself or not recuse himself. And the nature now of the case in itself is becoming more intertwined and more entangled. And one wonders, Tyrone, from your side, from your legal mind's basis, will we ever get to a point where we actually find out, get to the heart of this conversation around what happened during the arms deal? Who is to be accountable? What happened with the monies? Was there even guilt involved? Because so far we're dealing with the admin of the trial instead of dealing with the trial itself. And you got to ask the question, who does it favor? I mean, you always got to keep that in mind. I mean, I don't want to call it gamesmanship yet. We don't know. I don't want to impugn the integrity. It's called the game of chess, as our former head of state would be good at playing, right? Yes, I mean, you don't need to disclose whether you are playing a game or not, but it's not, to me, it's not inconceivable that, a delaying strategy here could be at play. Because think about it. I mean, it's difficult as a strategy to say, well, we're going to delay matters for as long as we can, such that witnesses, the state's witnesses are not able to give evidence, because it could take a long time. But if you got your back against the wall and your case is really, really poor, why wouldn't you do it? Why would you want to make the state's case easier? So for as long as you're raising legitimate obstacles for the state to cross and there's nothing illegal about it, why not? Jacob Zuma is in hospital now, he's not able to stand trial. Why wouldn't you raise it as a factor to say, well, you know what, he's not fit to stand trial? That's what the law says, that you got to be fit to stand trial. And if you deem me that your client is not fit to stand trial, you raise it. So for as long as they're raising things which in law are legitimate, that's what our law allows, and the state's got to keep finding ways to shoot down those skittles, essentially, which is what they're trying to do. So look into your law crystal ball, as it were, right now. And if you have to look at the happenings around this case in itself, are we yet to see a time where this matter will be heard fully in court? Or given your expertise, are we looking at a possible 5 years or so around the same mulberry bush, playing ring a roses, and as you say, the games that are involved in it? Yeah, I guess for me there are two answers. The one is as an officer of the court, which I can give, which is to say, well,
it's in the hands of the judge at this point. You know, the decisions have got to be made. We've got this special plea, as it were, that's going to be dealt with. There are all sorts of challenges that are coming up. Is Jacob Zuma going to be in court and be able to deal with that? Those decisions have to be made in terms of the law, and none of us can prejudge what these decisions will be as we go along. So for as long as the delays are systematic in that regard, well, so be it. That's what the law requires, and none of us could then know ultimately when the trial proper will start. Now, that's the one answer which I would give as an officer of the court. But realistically speaking, in my experience, and looking at the strategies being implemented here, it's a concern for me. It doesn't seem to me that there's actually a will, particularly on the defense side, to actually get this trial going. So they're quite happy to raise whatever legitimate defenses that they can in order to delay. To what end? I don't know. I mean, could it be that, here's the thing. If Jacob Zuma, if there's a declaration that he's not fit to stand trial on the reason that he is just simply unwell, and that argument is made in court, as it seems it may very well be, if the court then accepts that, well, then we cannot proceed. The question is that for how long? Well, then we've got to wait until he's able to stand trial, when he's fit enough to stand trial.
What if he's never fit to stand trial?
Well, that's my point. That's what I'm trying to drive at. Is that how then do you determine, when do you determine, and who determines whether at what point he's going to be fit to stand trial? Is an elderly man. His health is not going to start improving. And as a defense strategy, is it legitimate? Yes, if the court accepts that he's not able to stand trial. And they're going to argue this is going to come up. But the point is, if there are postponements for that reason, we don't know at which stage they will be able to resume proceedings again. Because the state is certainly not going to be going to Jacob Zuma every month to check, well, how are you, Mr. Zuma? You're well enough now to stand trial, and then can we press charges against you? So no one knows at this point where this is going to go.
Tyrone, sobering conversation, one that makes one wonder exactly whether or not we will actually hear the matter in court when it comes to, of course, the arms deal. But, of course, that was the legal expert Tyrone Maseko giving us the latest insights on that. Well,